Welcome to this edition of Real World Employment Law, where we discuss real-world issues impacting businesses and executives. I'm Declan Leonard. I head up the employment law practice here at Berenzweig Leonard.
And I'm Kristin Zech. I'm one of the employment lawyers here who handles our immigration matters.
And Kristin, we've got a great topic today. We're talking about the hiring process. You know, we both are employment lawyers, so we're talking about the hiring process, but specifically hiring an authorized workforce. What does that even mean?
So in the United States, any U.S. business has to have employees who are legally authorized to work in the U.S. That can come from any variety of ways. A U.S. citizen is legally authorized, permanent residents are authorized. Many individuals who are here for humanitarian purposes or on visas may be authorized.
Okay, so all of those. So sometimes people make the mistake of thinking, well, okay, what we're really talking about is U.S. citizens, but it's much broader than that, right?
It's much broader than that.
Okay.
And I think that's the key reason for us being here. We know about national origin. We've talked about Title VII.
Yes.
And most employers recognize that. But there's another law that applies here, which is IRCA, the Immigration Reform and Control Act. And that speaks in terms of citizenship discrimination, citizenship status discrimination in addition to national origin.
So most employers, and including employees, are familiar with what they call the Form I-9. Whenever you start a job, you've got to fill out this Form I-9. What is that whole process?
It is absolutely critical. So the Form I-9 is the form that employers use to determine whether or not an employee is in fact legally eligible to work in the United States. And it's a three-part form. Really, two parts only apply at the beginning of employment. One is who is the employee, some background on them, and then number two is the section where the employer actually reviews documents to determine whether or not the individual truly is who they say they are, and two, actually authorized to work in the United States.
Okay, but by the time an employee is filling out an I-9 form, they've already got the job. Congratulations, that's great. But what about during the hiring process? What is it that if I'm looking to hire somebody, what can I ask? Because I've got to comply with these laws that we just mentioned. So can I just come right out and say, hey, are you a U.S. citizen? Do you have a green card? Like, how do employers navigate through that process?
Absolutely not.
Okay.
So there are really two questions you want to focus on as an employer in your application process. One is, are you legally authorized to work in the United States?
Okay, so stop there. So that's kind of the catchphrase, right? Are you legally authorized? That won't get a company into trouble if they say it that way.
No.
That can pick up, you know, are you a citizen? Are you a green card holder or whatever? But you're not looking for that level of detail from their response. You just want to know, are you legally authorized to work in the United States?
That's correct.
Okay. And then you mentioned another question.
And then the second question is, do you now or will you in the future require visa sponsorship?
Okay. And is there any way that employers can just shortcut this process? Can't they just like kind of cut to the chase and say, look, give us your immigration documents, and that way we'll know for sure that there's not going to be a problem with you being able to work here?
Absolutely not. Not in the hiring process.
Okay. So it seems like these laws not only have their certain restrictions, but they have very specific processes that companies need to make sure that they follow. In other words, you just said no shortcuts. So what is sort of the best advice that you would say to a company as you're going through this process?
I think the key is to treat all of your applicants the same way. And that means that whether they're a U.S. citizen, whether they're a permanent resident, which you may not know, you don't want to, one, presume, and two, you don't want to treat them different. Again, the key is whether or not somebody's legally authorized to work in the U.S., not how long they're legally authorized for, not the basis of their authorization.
If you ultimately find out that they're U.S. citizens, that really doesn't present many issues moving forward. But what if they have some kind of an immigration status that requires employer sponsorship? What are employers' obligations with regard to sponsorships? And first, what are those different sponsorships?
Sure. So one of the ways that you can come to the United States either on a temporary basis or on a permanent basis is having your employer sponsor you for a visa.
Okay. To
be clear, there is absolutely no obligation whatsoever for an employer in the U.S. to go through the sponsorship process.
Oh, okay. So you know, if an employee comes to you, they look like a great candidate, but they require some kind of sponsorship, you can just say no.
That's correct.
Okay, and that's not a violation of any of these federal laws we're talking about?
Not at all.
Okay. Is an employer able to delve into, like, how long are you authorized to be here for?
That comes across when they complete the Form I-9 after the applicant has already been hired. But prior to that, it's really not something you as an employer should be looking at. And I understand the concern about having an employee who's only going to be here for a short period of time. But just because there's an expiration date on that authorization doesn't mean that the employee is not going to be able to work. It can be a situation where that individual is able to extend their status. They may be changing status to a different immigration status. The other side to this, too, is that generally speaking in the U.S., employment's at will.
Yeah.
Whenever you hire somebody, you never know whether they're going to stay for 1 day, 2 days, 2 years, 10 years. And I think that we need to approach that within the same context here.
So it sounds like it's best practice to kind of stay out of the weeds as to what exactly their immigration status is, how much longer they have or anything like that, or risk running afoul of some of these federal laws.
Are you legally authorized to work? Do you now or will you in the future require visa sponsorship?
Okay.
That's it.
And then, but there are some jobs. I mean, here we are in the Northern Virginia, the DMV area, where government contractors, are everywhere, and sometimes they have special requirements. Talk a little bit about that, whether it's security clearance or whether or not that would allow an employer to ask perhaps a little bit more deeper in terms of their immigration status.
Where this really comes up is within the context of a government contract, for example, that requires a U.S. citizen. And what the law says is that in certain circumstances where the law, regulation, executive order, or a particular government contract requires a U.S. citizen, that you are able to include that requirement either in your posting or in your description for that specific job.
What if it doesn't require, what if like the specific job posting doesn't say U.S. citizen, but does indicate that it will involve national security and will involve a security clearance? Are employers allowed to go a little bit deeper than what we talked about before for those situations?
Yes, but carefully. When we are dealing with a position that requires a security clearance, that's fine to relate that security clearance to that specific position. Where you could potentially run into issues is if you are constantly asking everybody who you are hiring whether or not they're eligible for a security clearance.
Got it, because not every position might have the same requirements, not even the same level of security clearance. So you should not adopt such an intrusive questioning if it doesn't apply.
That's correct. The concern is that you're going to have an applicant who may not be eligible for a security clearance who's going to look at that question and all of a sudden deem themselves excluded from your workforce. That's where we get into citizenship status discrimination.
Got it. Well, picking up on government contractors, and again, that's makes up such a large part of the economy here in the DMV, as well as, frankly, throughout the United States. You have situations where sometimes your prime contractor or sometimes your contracting officer at an agency will say, nope, I want U.S. citizens for this position, even though they don't fall under specific, U.S. citizen requirements. What's a company to do when you have a situation like that?
You have to say no, unless you have some evidence that you are required to have a U.S. citizen for that position. The answer is no. What's going to happen is the Department of Justice, in investigating citizenship status discrimination, will hold both companies liable if there truly is not a need for a U.S. citizen under the exception that I mentioned. Okay, got it. So it sounds like in a situation like that, the customer's not always right. There's got to be some pushback there. There has to be. Okay. I mean, it sounds like there are some legal pitfalls here. And so why wouldn't a company just kind of outsource this process, maybe just use an outside staffing company to deal with all this I-9 immigration regulations? They can, but at the same point, that company still needs to be sure that it's hiring and using individuals who are legally authorized to work in the United States. Okay, so in other words, you can't necessarily wipe your hands of it just because you're using a staffing. And in fact, you mentioned earlier that it may be that there's more than one company that runs afoul of these immigration laws. So if you use an outsourced staffing company, but you know that they're doing this, you know that they're not strictly complying with these immigration laws we're talking about, you yourself could also be held liable. That's correct. Okay, and the agency that investigates this, which agency is it? Is it EEOC or? Well, it depends. So in some cases, we're dealing with national origin discrimination relating to when somebody may be coming from a certain area, a certain region of the world, and they're being discriminated against because of that. Okay. That can be handled by both the EEOC as well as the Department of Justice. Okay. When we look at citizenship status discrimination, that's specifically handled by the Department of Justice. Okay, and companies, they don't want the EEOC on their backs. They definitely don't want the Department of Justice on their backs on this. So it's definitely something to pay attention to. In our practice areas, we've seen that sometimes companies, A, are not aware of this, or B, maybe sometimes take shortcuts when it comes to
compliance in the hiring process with, all of these immigration requirements.
That's correct. Sometimes there are shortcuts, and to be candid, sometimes there are just inadvertent issues that are just overlooked. They're not deemed to be a big issue at the time, but in hindsight, they could have been handled differently.
Kristin, thanks so much for joining me for this great discussion. Very important topic for employers.
Of course, Declan, it's always a pleasure.